Well, good afternoon, everyone. I'm going to give a minute for everyone to start loading on to our virtual presentation and welcome you to the annual meeting of the dispute resolution section of the Georgia State Bar. A little business meeting before we start a wonderful program for you this afternoon on difficult issues in arbitration with a great panel. We've been joking that we organized this terrific session, CLE session for you this afternoon to get as many of you to join the annual meeting as possible. So thank you for registering for the program and also spending a few minutes with us before we start on our annual meeting. A requirement of the State Bar for the sections to hold an annual meeting, and we're very excited and proud to present to our section members a little bit of the update on our section and some announcements and voting with regard to some of the things that we've been doing. So let me start out very quickly. It looks like we've got folks that are loaded on now. Again, my name is Scott Zucker. I'm the chair of the dispute resolution section. Almost done with my term. It's been a fun year and want to report to you a very successful year. We've started with our programming back in July of 2023 and have not missed a month in terms of doing programming on mediation or arbitration for the section. We've had the pleasure of working with the Georgia Office of Dispute Resolution on a large event in November. We've worked with the trial practice group, the domestic relations sections, putting on programs since this summer, and want to let you know in advance now that after this program today that you're lucky enough to be attending, we will be having a program on April 18th, another Lunch and Learn. That one will be with Ray Chadwick and the president of the State Bar of Georgia, Tony Del Campo, who's been nice enough to agree to join us as an experienced litigator and mediator to talk about sort of difficult issues in mediation. So we're looking forward to that program. Please put that on your calendars for lunchtime on April 18th. And then finally, our sort of the coup of the year is a program on May 16th from 5 p.m. to 7 p.m. held at the State Bar called Meet the Mediators, a free open cocktail hour hors d'oeuvres sponsored by the section and a number of mediation groups for mediators and lawyers and administrators to get together and network and to meet each other and to basically meet the mediators that are part of the State Bar. And that, again, is on May 16th from 5 to 7 p.m., held at the State Bar offices, free to register. And we invite all of you to attend and get to network and learn together. So quickly, for the annual report for our section, we currently sit as section members of 615 members of the dispute resolution section with a bank account of approximately $67,000 to spend on section activities. Thank you for your continued contributions to the section. We will use that money wisely and continue to put on programming as we've done this year and will continue into next year. There are a few items that need to have voting this afternoon, and one is the fact that we've been working since Erica Berg, who's going to be a speaker in a minute, since her chairmanship of this section, to update the bylaws of the dispute resolution section to bring them in line with the other sections in the State Bar. The State Bar has created a modernization of the bylaws to fit within the sections. Our bylaws are possibly about 20 years old, so needed to be updated. Those proposed bylaws have been submitted to you as part of the invitation today for your availability and review. And I would like a motion to approve the new bylaws of this section, if I could hear that and record motion that. I hear from Joyce a motion to approve.
Mark Daylor will do a second.
All right, Mark Daylor. Thank you, Mark. Doing a second. Any discussion on the proposed bylaws that have been submitted to the group? Anyone have any comments other than to, again, thank Erica for her work in getting this initiated and for our board to finally get it done. So I know many of you are not on view, but I'm going to say all in favor. I hear
Aye.
ayes.
Aye.
Any opposed?
Aye.
Okay, we're gonna pass the bylaws for our section. Not significant changes, again, as you can see, but brought them up to date to meet the other section bylaws of the other groups in the state bar. Next, I have the pleasure to announce and propose the slate of your board members for the next annual year, starting in June through next June 2025. Boy, that seems a long time away, but here we are coming up to June of 2024. The proposed slate has been provided to you will be Chair Sean Moman, Vice Chair Joyce Clemmer, Secretary Doug Witten, Treasurer Casey Crumbly, and our at-large members Erica Berg, Ray Chadwick, Mark Daler, Sam Sparks, and the Honorable Gail Tucson. I'd like a motion to approve the slate, if I might.
Scott, I move to approve the slate as presented.
Thank you, Sean. No bias in that motion at all. But thank you. I hear a motion by Sean to approve the slate. Any second?
I'll go ahead and second, even though it's self-interest.
It all works for us, everyone. Thank you. Ray, second. I'm going to put it out to the members. All those in favor of the slate, say aye.
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 Any opposed? Any opposed other than Sean, who's agreeing to the leadership? All right. Motion passes. And that will be your slate for 2024, 2025. Boy, that didn't take long at all. I do want to open it up to the group that if you have any, since we have a large group today, before we turn it over to the programming, if you have any suggestions, particular interests with regard to the mediation dispute resolution section, performing any education or programming for this section, please reach out to me, and then certainly in June to Sean, because we want to make it the best that we can for you guys. Again, I really want to thank the board members for this year and everyone that's stepped up to manage and plan these programs that we've done every month. I think we're sort of setting new records of having a program available for all of you each month. And I think the programs have been great, and will continue to do so. I think we're really lucky to have Tony, our State Bar President, presenting for us in April, and then look forward to seeing all of you live at the State Bar on May 16th between 5 and 7 p.m. for free drinks and yummy food and an opportunity to be together as a group. Okay, hearing nothing further, I'm going to close. Oh, well, so I just got a note that the CLE is advertised to begin at 12:30, so we can do some filler, but I think we're okay. I think we're okay. We've got a good group, and if people come in a little late, I'm going to give them CLE credit anyway. So unless there's anything else that anyone else has.
Scott, I have one question.
Yes.
One question on the May 16th meet and greet at the State Bar. Did you say you need to register for that?
You'll see an advertisement come out soon, an invitation. Yes, you'll need to RSVP so we know what the numbers are for enough food and drink. The notice hasn't gone out yet. I just want you to put in your calendars, but you'll see the invite go to all section members.
Okay.
All right.
Will we be doing that cross with the litigation section?
Yeah, the Georgia Trial Practice section for the State Bar is a co-sponsor of the event. Yes. As well as the Young Lawyers Division will be also co-sponsoring, and as well as some other of the mediation groups in the state will be joining us as well. A few details to work out, but you'll see an invitation with all the sponsors coming up soon. All right. I think we're okay to start the program. I think people need to sort of connect. So anyway, I am going to close the meeting. Again, thank you to the board for everything they did this year. And now I'm going to have the pleasure of introducing this program for the session. This is Difficult Issues in Arbitration. as you've seen, presented by Joe Loveland, Joyce Clemmer, and Erica Berg. Let me do some introductions of our speakers. You all know these fine lawyers already, but let me tell you a little bit about them as we get started here. Let me start with Erica. Erica, our past chair of the dispute resolution section of the State Bar, is a partner of Nelson Mullins, helps business owners, officers, and directors protect their company's interests before, during, and after litigation, has tremendous experience in resolving disputes in arbitration, mediation, state and federal courts throughout the country, certainly as a first chair trial attorney, but also as a sole arbitrator or chair of three-person arbitration panels, a lot of experience in arbitration. Her cases involve business torts, contract disputes, software implementation issues, trade secret misappropriation, computer fraud, etc. She chairs Nelson Mullins' Trade Secret and Employee Mobility Practice Group. So welcome, Erica. Next, I'm going to introduce Joyce Clemmer. Joyce is with JAMS and joined JAMS following a successful career spanning more than 3 decades representing U.S. and European clients in complex intellectual property and business and commercial litigation. As a mediator, she's known for her commitment and creativity to settling disputes. As an arbitrator, known for her careful attention to the facts and the law. She has an active mediation practice with JAMS, handling matters copyright, patent, trademark infringement, trade secrets, related commercial contract and licensing disputes. Joyce, as you see, is an officer, board member of the State Bar and a previous board member and chair of the Atlanta Bar Dispute Resolution Group as well. And finally, Joe Loveland. Joe is also a JAMS arbitrator and mediator, a full-time neutral following decades of experience as a trial and appellate litigator. We're just hearing about one of Joe's cases that he's involved in right now. A fellow of the American College of Trial Lawyers. Before joining JAMS, he served as lead trial and appellate counsel for both plaintiffs and defendants in complex contract disputes, business torts, and financial litigation throughout the United States. His business cases involve accountant liability, financial fraud, fraudulent conveyance, product distribution agreements, antitrust, securities fraud, intellectual property, and many others. Since joining JAMS, he has served as a mediator for complex disputes involving similar issues, including real estate limited partnerships, distributor-supplier agreements, and securities claims. We're very lucky to have such well-established and experienced arbitrators presenting to us this afternoon on the difficult issues in arbitration. I'm going to turn it over to them, but please, I will be watching the chat. Save your questions for each of them as they do their particular sections. We're going to save time at the end of this session for questions and answers. So please just put your question in the chat and I will then call out those questions at the end of the session. And that's it. I'm going to turn it over to Joe, Erica, and Joyce. And thank you very much for presenting today.
Actually, Scott.
Yes.
This is Larry Cunin. I joined a couple of minutes late. This is my first meeting with everyone, which is a little awkward on Zoom. I know I can see Erica smiling. I know Erica. And I met you last week at the Atlanta Bar ADR section. And I just wanted to say hello to everybody because I intend this to be my first of many meetings.
Well, thank you, Larry. Thank you for joining us. And we'll have a chance to have some folks say hi at the end of the meeting as well after the Q&A. But thanks for joining us. Thanks, everyone, for joining us. We have a tremendous turnout today, again, because of our great speakers. So I'm going to turn it over to the panel and stand by to coordinate questions at the end. Thanks, everybody.
Good afternoon. I'm Joyce Clemmer. As Scott said, most of my mediation cases are intellectual property cases because that was my background in practicing law. But the majority of my time with JAMS, since I have joined JAMS, has been as an arbitrator in commercial cases, which I also did when I was a partner in a major law firm in Atlanta. So the topic I'm talking on today is really quite a narrow one: proper parties in arbitration and who decides, the court or the arbitrator. I raise that issue because in recent years, I've been confronted with cases that raise issues of whether a non-signatory party can assert claims in arbitration, and whether a signatory party can assert claims against a non-signatory. Now, what do I mean by signatory versus non-signatory? I think all of us have heard that, the heart of arbitration is agreement, that the parties have agreed to arbitrate and accordingly waive their right to a jury trial. So when I speak about a signatory versus a non-signatory, what I'm saying is a signatory being someone who actually signed the arbitration agreement, and then a non-signatory being someone who did not sign the arbitration agreement, but yet is being brought into the arbitration under a number of different theories. And it's easy to understand why there's a lot of confusion in this area as to whether the court decides or the arbitrator decides. And although it's not necessarily the genesis of the problem, I think a lot of the confusion in this area stems from a Supreme Court case that I'm going to be talking about in a little while, which is Henry Schein versus Archer, decided in 2019. Because in recent years, the courts have been confronted with this question of proper parties, who decides, the court or the arbitrator. When it comes to non-signatories, both federal and state law have recognized 6 theories for binding non-signatories to the arbitration agreement. Incorporation by reference, such as where parties A and B signed an agreement, and then they signed a second agreement. The first agreement has an arbitration clause, the second agreement does not. But it incorporates by reference the first agreement. So incorporation by reference. Assumption, agency, veil piercing, also called alter ego, estoppel, and third-party beneficiaries. The way the argument has gone when it has been presented to me in arbitration is that federal and state law have recognized these exceptions. The non-signatory falls into one of those 6 categories. It's usually accompanied by citations to cases that say that the law favors arbitration, when in actuality, the law is neutral on it. And the arbitration agreement either has an express delegation clause, giving power to the arbitrator to decide, or it incorporates the rules of an arbitral provider, such as JAMS or AAA. And the argument then concludes that therefore, it's the arbitrator that has the power to decide whether the non-signatory may or must be compelled to arbitrate. Why do these issues come up? Well, quite naturally, and as a litigator, for the sake of your client, you want to avoid simultaneous proceedings, one going forward in litigation, one in arbitration, with the possibility of differing results in both cases. You want to bring all parties into one proceeding. Perhaps the non-signatory is the party in the strongest financial position to satisfy an award. Imagine an agreement between Company A and Company B, and Company B is now financially insolvent, but the sole owners of that company are not. Numerous reasons, in some cases wanting to avoid or take advantage of the finality of arbitration awards, which can only be vacated, that is set aside, for corruption, fraud, evident partiality, easy for me to say, misconduct, misbehavior, and exceeding the powers granted to them. So as I said before, when can non-signatories be compelled to arbitrate? Traditional principles of state law may allow a contract to be enforced by an agent for or against non-parties to the contract through assumption, piercing the corporate veil, alter ego, incorporation by reference, third-party beneficiary, waiver, and estoppel. I think all of us are probably familiar with most of those concepts, those principles, but they're also discussed in part in the paper that I submitted. Now, a court always has the power to decide whether a non-signatory can bring a claim or be compelled to arbitrate. And sections 3 and 4 of the Federal Arbitration Act concern stays of litigation in favor of arbitration and motions to compel arbitration. And the Georgia Arbitration Act contains similar provisions. Again, those are cited in the paper. But what happens if a party doesn't go to court to get a determination whether the non-signatory can be compelled to arbitrate, and instead goes directly to an arbitration tribunal, sorry, such as JAMS or AAA? They just file an arbitration. That's when I'll hear the arguments. And let me back up a little bit. What happens when they file the arbitration? The AAA and JAMS have rules saying that the arbitrator determines his or her own jurisdiction. And JAMS rule also says the arbitrator will decide who are the proper parties. But as I'm going to discuss now, that may be a little overbroad. The question of our arbitrability has two aspects to it, two prongs: the gateway prong and the who decides prong. And if there is a delegation clause, who decides, the court or the arbitrator? In Henry Schein versus Archer and White, decided in 2019, which I submit may be the main cause of the problem, the court held that when the contract delegates arbitrability questions to an arbitrator, the courts must respect the party's decision. But the court didn't disturb an earlier case that it decided in 1995 called First Options of Chicago versus Kaplan. In First Options, the court held there must be clear and unmistakable evidence that the parties agreed to have the arbitrator decide arbitrability issues. Now, over the years, 12 out of 13 circuit courts have decided that delegation clauses should be upheld. The question now becomes, does the incorporation of an arbitration provider's rules constitute clear and unmistakable evidence that the parties agreed to have an arbitrator decide whether the arbitration agreement encompasses claims made by or against non-signatories? It's not infrequent that the arbitration agreement will specify an arbitration provider's rules, such as AAA or JAMS rules. And as I said, 12 out of the 13 circuits to address the issue have found that incorporation of the rules, either AAA rules or the JAMS rules, provides clear and unmistakable evidence that the parties agreed to arbitrate arbitrability. So if there is a delegation clause, does the arbitrator decide if the non-signatory is a proper party? Unless the parties agree to the arbitrator deciding the issue, or a party waives its objection by subsequent conduct, the court, not the arbitrator, decides whether a non-signator is a proper party. I've made reference to a Third Circuit case in my paper that described it as the mind-bending question that has been dubbed the queen of all threshold issues in arbitration law. Who decides, a court or an arbitrator, whether an agreement exists when the putative agreement includes an arbitration provision empowering an arbitrator to decide whether an agreement exists? In that case, the Third Circuit, consistent with a number of other circuits, sister circuits as it called it, have concluded that no, the fact that there is a delegation clause, in essence, puts the cart before the horse. Because before you can have an enforceable arbitration agreement, you first have to establish that there is, in fact, an agreement between these parties to arbitrate. And when it comes to a question of formation of the contract, i.e. between the signatory and the non-signatory, that's a question for the court. I've cited a case called Lloyd's Syndicate 457. And I think that they made it pretty clear. The court in that case held that to assess whether a claim must be arbitrated, we follow a two-step analysis. At step one, the court must determine whether the parties entered into any arbitration agreement at all. The first step is a question of contract formation only. Did the parties form a valid agreement to arbitrate some set of the claims? And only if we answer yes at the first step do we proceed to the second prong. At step two, we engage in the limited inquiry whether the parties' agreement contains a valid delegation clause. There isn't a lot of writing on this particular subject. There is what I have found, I've cited in the paper. But if the challenge is I'm not directly or inferably a party to the agreement containing the arbitration clause, that's a contract formation or a contract existence challenge. And the delegation clause in that situation is typically useless. Thank you.
I'm going to pick up where Joyce left off, and frankly, in an area that's not nearly as intellectually challenging as the question of who the parties in arbitration are. I'm going to talk a little bit about the issues of discovery and arbitration and how they play out. And this is much more of a practical discussion than really an intellectual discussion at one level. But when we get into the issue of discovery from non-parties, you have many of the same issues intellectually that you have on the question of, just the power of an arbitrator when you're dealing outside of the contract that you're dealing with. So let's start with the notion of discovery from the parties and how that's done. And as I said, a lot of this is practical, just working it out. And the fundamental principle that I think guides this in arbitration is set the rules early. In the initial conference that you have with the arbitrator, discuss and establish the limits of discovery that you're going to allow in the case. The fundamental principle, at least in JAMS arbitration and to a large extent in AAA arbitration, is that there's a fundamental reliance on the good faith disclosure of the parties of relevant information and relevant documents. So to the extent there's a contract, the contract documents, the documents with regard to negotiations, correspondence, and then you get into the more difficult issues of electronic discovery, emails, etc. But all of that basic core material that's fundamental to the dispute, generally in arbitrations, the arbitrators are going to say, get it disclosed early and get that underway. Now, when you get past that, there's very broad discretion usually with the arbitrators on what sort of discovery is allowed, subject to two basic principles. One, since arbitration is inherently a contract situation, the parties can limit discovery if they choose to in their arbitration provision. They can say that they will be subject to arbitration, but discovery will be limited in particular ways. And I think 99% of arbitrators will abide by that if the parties have done that. The second critical area is the type of arbitration. For example, there's many types of consumer arbitrations that are set up. And in those arrangements, generally, the discovery is very limited. It's set out usually no more than a deposition of the claimant, one deposition of the respondent, very limited discovery, because the matters frequently don't involve a great deal of money. And at the same time, I think my role as an arbitrator, when I look at it, is that I recognize that many of these consumer arbitrations or arbitrations of that nature are situations where the contract provision was written by the respondent, basically, and limited the rights of the consumer in many ways. And so while you want to honor the contract, and you have to honor the contract, you also want to make sure that there's going to be enough discovery to provide for a fair hearing. And that's an area, again, where I think it's critically important in the early conferences to sit down and talk about, what are we going to do here? What's the limit of discovery? Does anybody disagree? My experience is frequently everybody agrees with that, because the claimant's attorney on the consumer arbitrations is frequently representing hundreds of different claimants in these arbitrations, and they don't want to get involved in a massive discovery dispute. You do have the situation where the respondent sometimes wants to put some extra burden on the plaintiff, and you as the arbitrator have to be aware of that and be very cautious about it. Now let's move outside of the consumer area into sort of the more broad-based, just commercial arbitration, intellectual property disputes, and those sorts of things. And that's where I think you really, in the arbitration context, face many of the same problems you face in commercial litigation or in intellectual property litigation or any other sort of major litigation. And that is, where do you set the boundaries? I think it's fair to say that most arbitrators are starting from the assumption that the parties are in arbitration in part to simplify the process, in part to expedite the process, and in part to avoid many of the disputes that you have in ordinary civil litigation. So again, I think my role as an arbitrator is to, at the very early stages, say, okay, what do we need for discovery here? How many depositions are we going to allow for each side? What's the length of time that we're going to allow for depositions? What sort of document production are we going to have in the case? Is there going to be electronically stored information? If so, what sort of ESI protocols are we going to establish? You have the same issues of confidentiality agreements that you would have in civil litigation in many of these cases. And all of those things, from an arbitrator's point of view and from a participant's point of view, you want clarified on the front end as much as possible. Let me say that something that I don't see in arbitration, and something that I saw a fair amount of in my litigation practice over many years, was what could be called the discovery tort, where the matter shifts from not the merits of the litigation to who's done what they were supposed to do in discovery. I know that and I think most arbitrators have very little interest in that sort of issue. They want to make sure that the facts are discovered, that the information is produced, but there's not a whole lot of blame that people want to attach to things. That being said, I also have seen situations where it's pretty clear that one side is dragging their feet in the production of materials, or making extraordinarily broad privilege claims that all of our information, internal information in this matter, is protected by privilege because we knew this dispute was coming down the road, and it would be burdensome for us to do a privilege log or do that sort of thing. You have to work through those as the arbitrator. I know my view basically is I don't buy blanket claims. I will, if necessary, require a party to produce a privilege log and maybe to have in-camera inspection of privilege claim documents, and to work through them. I hate doing it. I mean, I really hate doing it. And I strongly encourage the parties to make sure that before they're asserting a privilege claim, they really want to assert the claim of privilege, and that is really something that is important for them to do it on. The electronically stored information rules and protocols, as I said, are also not much different in arbitration than they are in litigation. but it's very clear that you need to establish them up front and be clear on them. My own experience over time has been that if the parties are in arbitration pursuant to an agreement, they understand that they need to do the discovery, get it done, and move it on. And I must say, I find that the number of disputes over discovery issues is smaller than I would have anticipated in most arbitrations. They do exist. They tend to focus on privilege questions, or they tend to focus on someone who is trying to limit the scope of arbitration, the scope of discovery more than it should be. But I find it to be not a frequent issue. I want to shift for a moment, though, and talk about the one area that is problematic in discovery, and that is discovery from non-parties in arbitration. And just as Joyce said, because arbitrations are basically where a party has contractually agreed to cede power to an arbitrator to make decisions and to evaluate various things, the same thing happens in discovery. The non-party hasn't ceded anything to an arbitrator to decide about what can be required of a non-party. And most non-parties, or many non-parties, are going to object strenuously to any sort of extensive discovery requests, broad subpoenas for productions of all types of documents, et cetera, that you would see. Let me make a pivot back to a point about the party discovery. One thing that I do as a arbitrator, and I think many arbitrators do, is I tell parties on the front end, if you want documents, you've got to be specific about the documents you want the other side to produce. We're not going to have, all documents related to or, with regard to X or Y. Specify the types of documents you want, specify the time frame that it's relevant to, specify to the extent you can the people or parties that you think have that information, because the all documents related to requests, which you see all the time in civil discovery, is simply something that most arbitrators are not going to think is tailored to meet the needs of arbitration. So now let me pivot back to the notion of non-party arbitration. Georgia's lucky. The Georgia Arbitration Act actually has a provision, Georgia Code 999, that on its face authorizes subpoenas to be issued for the attendance of witnesses and the production of books, records, documents, and other evidence, and provides that the subpoenas shall be served upon and upon application to the court by a party or the arbitrators, enforced in the same manner provided by law for the service and enforcement of subpoenas in civil actions. So a broad-based ability to have subpoenas issued in Georgia under the Georgia Arbitration Act. Draw a clear distinction, though, between that and the Federal Arbitration Act. And so you're going to get to the question of what rules apply. What rules have the parties specified? Has there been does the Georgia Arbitration Act apply on its face because of the nature of the dispute in the parties? Federal Arbitration Act will obviously be a default for many things. The Federal Arbitration Act is more limited. The language, Section 7 of the Federal Arbitration Act, basically says that, the arbitrators selected, prescribed by the title, may summons in writing any person to attend before them or any of them as a witness, and in a proper case, to bring books, records with them. So the language that is in there, which is summons in writing any person to appear before them or to attend before them, has been the subject of substantial litigation in the federal courts. And the question has been, does this mean there's no pre-hearing discovery from non-parties? The answer seems to be increasingly, in most jurisdictions, that's what it says and that's what it means. The 11th Circuit in particular had an important decision in the Managed Care Advisory Group versus Cigna case in 2019. Let me say, I think it's fascinating this case was decided in 2019, the year before COVID, because I actually believe had this case arisen 18 months later, practical considerations may well have led to a result that's different from the result in the opinion in 2019. But faced with the decision in 2019, the 11th Circuit basically said the words in the Federal Arbitration Act say what they say and mean what they say. And that is, there is no pre-hearing discovery from non-parties, and there is only the production of witnesses or documents at the hearing before the arbitrator. That opinion actually suggests that, yeah, you can't avoid it by saying, I'm going to have a discovery hearing, and I, the arbitrator, am going to sit in Atlanta, and you guys are going to go conduct a deposition in Chicago and of a non-party, but I'll be there by Zoom. And suggest, no, that's not going to work. It has to be attend before them, and that means physically, and that's the suggestion in the case. Again, I think had the case been decided a year and a half later, there may have been a very different result as judges understood much more about, having hearings on Zoom, doing things on Zoom, how effective it was working, et cetera. But that's where we are. One question that is still open in all of this is, does it have to be the final hearing? Can you, for example, say, all right, I'm going to have a hearing. And it's going to be before me. I'll actually attend, and they'll bring in the witness and produce the documents, have the non-party discovery. It'll be a hearing, but it's not the final hearing. Or alternatively, can you say, all right, well, our final hearing is going to be bifurcated. Days 1, 2, and 3 are going to be days where we effectively conduct the discovery aspect of it, and have the documents produced and the testimony of the non-party witnesses. And then we'll take a break, and we'll have a hearing, an extra part of the hearing down the road, and we'll evaluate that. My experience talking to arbitrators is that there's a lot of machinations going on right now about how to work through this and how to provide the parties the opportunity to get discovery that's really needed, and at the same time, not fly in the face of the words of the Federal Arbitration Act. That's an evolving process. I think it's going to be fascinating to see how it comes about over the next few years. There is one very practical aspect to it, though. People really think carefully about what they need from non-parties. I think you really evaluate, is this really important to me? Because unless it's really important, the hoops you're going to have to jump through and the expense it's going to add to the arbitration probably means it's not necessary and you're going to avoid it. So those are some of the issues that we're dealing with in discovery and arbitration now. Turn it over to Erica. Erica, you're on mute.
Even 2024, and I still can't remember to take myself off mute. I'm so sorry. Lynn, can you put up that poll for me? I want to get a sense of our viewers, our participants today, on where they are with respect to their practice. I don't know. There we go. So if you guys would answer this really quickly so I can make sure that I'm directing my comments to all of you, that would be great. I appreciate it. So I'll get started. So I'm tasked at the end of this to talk about the different types of awards that arbitrators are issuing. And I think I'm going to start with the punchline. Whatever you do as an arbitrator, make sure you have the parties' consent to do this because of the way our statutes are written. The most, and Lane, just pop in whenever we've got the poll results. The most important thing to remember is that for those of you who are still advocates and in arbitration, that you have to object if you don't like something. And you have to, if you're in the AAA's rules, for example, or operating under the Georgia Arbitration Code, you have to make sure you object in writing. The FAA is a little bit different. It is not as specific as the Georgia Arbitration Code is on some of these issues. So one of the things that we have seen sort of as a trend in arbitration is arbitrators taking interim awards. And they'll take these and they'll make these interim awards because there has been a motion, a dispositive motion. And so we've seen it more and more, particularly after JAMS and AAA recognized that there is an opportunity for getting rid of some of the issues, deciding some matters that should be decided as a matter of law before the hearing. So for example, is there a statute of limitations defense? Okay, we got it really spread out. So this is great. And I think my comments then will be very helpful for everybody in the group. So the trend we see with these interim awards has been it's coincided with the change in the rules and the update that we're going to have some sort of summary judgment dispositive motion practice. And it happens with respect to certain issues. Can they state this claim? Do they have standing to state this claim? Is there a statute of limitations issue? Some of those things, or even a contract interpretation issue where there is no ambiguity and you want to decide that contract issue before you get into the final hearing. So what arbitrators have started to do is to do three different types of awards. You have the interim award, you have the partial final award, and then you have the final award. And interim awards are ones that I think are the most troubling to me personally, both as an experience of being asked for them and having them issued in my cases. And the reason being is that at least under the Georgia Arbitration Code, which will apply many times to your limited liability company disputes, your business divorces, your other interstate contracts. So you can think about it as real estate contracts and other things that are wholly intrastate, excuse me. So there you're going to have the Georgia Arbitration Code apply. And when you do that, the Georgia Arbitration Code only speaks to one award, an award, the award. There's not awards. There's not a plural ever used in the code. The assumption is that there's going to be a single award. So you've got to, how does that code then relate to when an arbitrator's issuing an interim award? Well, advocates out there, you better, if you don't like that interim award, you better know your clock started to run to head over to the Fulton County Business Court, statewide business court, or your other superior court to go move to vacate that award or get it modified, because that time starts to run as soon as that interim award is done. If you're governed by the Federal Arbitration Act, then you can't do anything with the award, because the courts will say, particularly here in the 11th Circuit, will say we only have jurisdiction over final awards. We're not doing partial awards, and the arbitrator is maintaining jurisdiction, therefore it's not final. But in Georgia, our courts have recognized that you can get your interim award confirmed. So say you got injunctive relief or something like that and you want to go get it confirmed, you can go down to the courthouse and go get that relief, because you need to, as I think most people in this audience will know, to the extent that you get an arbitration award, it's only worth the paper that it's written on until you get a court to bless it and make it a judgment of the court. So if you want to vacate it though or modify it, you got to go. You better get started. You better go. The problem then becomes is that your arbitrator now knows that you are seeking to vacate his or her award, and things just go downhill from there. It is the relationship and the trust and the things that go on when you do an interim award are really imperiled, because now you really do have somebody who's mad, right? And it makes it very difficult for you to maintain the control over those proceedings. But you also have to make sure, arbitrators out there and advocates, did you ever tell the parties you were going to do an interim award, or did you sneak it in the preliminary scheduling order? For advocates out there, make sure that the arbitrator didn't reserve all sorts of rights to him or herself to address awards in some fashion in the preliminary scheduling order. And I've seen this, and this is a trick. If you want to do it as an arbitrator, put at the end of your preliminary planning award, any objections to this order need to be made within 10 days or deemed waived. Then if the arbitrators preserve power to issue any types of interim awards other than one single final award, they've gotten the party's consent, and there's nothing that the party can do about it. So I think if you're going to issue an interim award, what you're really better off doing is entering a partial final award as to certain issues. And there you have the finality. You've addressed the scope. Hopefully you've gotten the party's consent that these are the issues you're going to issue a partial final award on. And then it is clear that you intended as the arbitrator to issue all of the relief on those specific issues that you were going to do. And the reason that becomes important is because when they do take that to court, because as soon as that partial final award is issued, that procedure starts, that clock starts to run. The same rules under the Georgia Arbitration Code or under the FAA for vacating awards start to take effect, right? So did you overstep your authority? Did you issue a complete award? Was it vague? Was it ambiguous? Did you miss something? What was the problem with the award? And that doesn't necessarily address some of the other things that Joyce was talking about, arbitral bias and so forth. But really, it goes down to, did the arbitrators do what they were supposed to do with the issues that were presented to them? And those are the types of things that oftentimes do result in a modification or even a vacation of the award, followed by a remand to the original arbitrator. But then it's final and it's clear. So when you've got those summary disposition issues, the better way to handle it to me is always to issue a partial final award, said, I'm done, I'm finished. And the other part to that is then some of you may not be familiar with the doctrine of functus officio, which means the arbitrator's jurisdiction ends the minute they issue that award. And so at that point in time, when you've issued a partial final award, your jurisdiction to revisit those issues is extinguished, right? It is moving on, and you have jurisdiction only over what's left. That provides certainty to the parties. An interim award doesn't provide that certainty. It makes it this gray area. And I've had awards where we've got interim award 1, interim award 2, interim award 3, and my final award, which addresses other issues and incorporates all the other interim awards. And that just creates problems for the parties on dealing with sort of this successive decision making. And it it really does encourage some distrust in the process. And so it's, to me, avoiding that interim award where is appropriate. I also question, although I have not found any cases on that, going back to the interim award, whether when you issue an interim award, if it doesn't address all of the issues in the case, is it subject to vacatur because you didn't do that? Some creative advocate will test that in our Georgia Court of Appeals, I'm sure. So the best part and the best way is doing the final award and letting the parties know that those are, all of the issues are going to be decided in that final award. And I have taken to, at the beginning of every arbitration, ensuring that there is a checklist of the issues. So sometimes you get complicated cases where there are different facts, different remedies, different timeframes. And so I usually articulate the issues. These are the issues that we're going to decide in this arbitration. Anybody have any other issue you believe is on the table for us to be decided in our final award? Speak now or forever hold your peace. And so that when we have that, we can go forward at the end when we're doing our award writing to making sure that we have checked all of the boxes. And in some of these arbitrations that last, over several weeks, it is so important to make sure that you've got the whole bundle, right? You know everything. But if you miss something, and it does happen, right? The parties have tried to come back to you. You still have this problem. I've issued my final award. I can't add to it because the rules on modification don't allow us to do that. So really important, I think, as just a practical matter, if you're an advocate or an arbitrator, to make sure that you're asking for, or even if you're as an advocate in your opening statement, these are the issues that you're going to have to decide. And so that you have that record. And if you have, you as arbitrators and advocates, consent to the process is the foundation of arbitration. Everybody is there because they agreed to be there, and they get the right to agree to the process by which their dispute will be decided. So respecting their role in deciding on that, getting consent, getting buy-in to the process is, I think, is key. Really, really important. So that's my bid on awards.
Thank you, Erica, Joyce, and Joe, for your very succinct and complete presentations on these difficult areas in arbitration. As I said earlier, and I have to apologize, we did start a few minutes early because the annual meeting finished early. So for those of you who jumped on at 12:30 and you heard our speakers already presenting, we did start a few minutes early. But we wanted to open it up really for dialogue and questions on these arbitration issues. And I want to defer, and I hopefully, Lane, you can open it up for people to come off of mute and ask questions. I saw there's a Q&A from Henry Killian. So Henry, if you want to ask your question, I don't know if we can unmute you. Otherwise, I'm gonna have to read it. So Lane, can you tell me whether I have to read it or I
he should be able to unmute himself.
I'm sorry?
He can unmute himself. He's unmuted.
Oh, Henry. So if you want to ask the question, it's very
yeah,
helpful question. Go ahead.
So I'm unmuted, and I guess you can hear me. Can you hear me?
Yep, we can hear you.
Okay. Thanks to y'all, you all. The question is, well, the history is, we had a construction contract that and we had a dispute, and the other side, the contract itself said nothing about the Federal Arbitration Act. However, it referenced rules for a local arbitration forum that referenced the Georgia Arbitration Code with respect to discovery, et cetera, and other procedure. The other side took the position the FAA preempted the rules and the Georgia Arbitration Code, thereby precluding any non-party discovery. And we fought back and said, well, the FAA may apply for purposes of getting the arbitration going and enforcing the arbitrability of the matter, but that the rules that you referenced in your form contract, specifically called upon the FGAC, Georgia Arbitration Code, for discovery, et cetera. So we succeeded in getting the arbitrator to find that the scope of preemption was very limited and that she had the power to issue subpoenas and otherwise get non-parties to appear and bring documents without having to go to federal court, or they could produce documents before the hearing to us. And I was wondering whether you agree with that conclusion.
Henry, from my perspective, I agree with that. I would probably reach exactly the same conclusion as an arbitrator under the facts that you articulated, which is that the agreement itself referenced the Georgia Arbitration Act and its provisions there. I don't believe the federal courts that I'm aware of have held that the FAA's provision precludes other rules or the rules of other forums applying if they're specifically called for. And under those circumstances, I think you reached the right resolution. Had your agreement not referenced the Georgia rules, it would be a more difficult issue. And I frankly don't know exactly how it'd come out on that one.
And any other comments on that from the esteemed panelists?
I'll add something to that. Oh, Erica, go ahead.
Okay, go ahead.
There are numerous aspects of arbitration that the FAA does not address. And so while the FAA preempts conflicting state laws, it doesn't preempt everything. And so, again, as Joe said, it's an undecided issue, but I've had at least one case where I said that actually both could apply. You know, the Georgia Arbitration Code could apply to the extent it's not preempted by the Federal Arbitration Act. And as to that specific aspect of the case, the issue, whatever the matter was, it did not preempt.
And the other thing I was going to add to it is making sure that you address those issues early in the case. I know at least the AAA's preliminary planning report that we do, or scheduling order, I'm confusing my terms with the Northern District of Georgia, but the scheduling order that we do at the beginning of the arbitration. And at that point in time, there's a spot to say, what is our governing law? Is it the Georgia Arbitration Code, or is it the Federal Arbitration Act? And most parties and arbitrators are not prepared to discuss that point when you get into the case. And more, I think more education around that will be really helpful to everyone. Learn it. If you're in arbitration, learn what those are and why you might want one over the other. So I oftentimes will advocate for the Georgia Arbitration Code because it is more detailed than the Federal Arbitration Act. I also like the provisions for vacating an award or modifying an award. I like that there are rules about what the arbitrator is supposed to keep as a record of the arbitration. And I bet most of you don't even know that Georgia requires you to maintain a record of the arbitration proceedings, which includes the witnesses and the testimony that was received. It doesn't have to be a stenographic record, but you're supposed to keep at least a list of the documents and so forth in there. So there is a lot in the Georgia Arbitration Code that is helpful. I will note for those who are familiar with the revised uniform code for arbitration, we don't have that. Florida does. So different states have different rules about that, but the Georgia Arbitration Code works pretty well. And so for those looking at that issue, when you get before that preliminary conference, make sure you understand what you're agreeing to when you say, yes, the Federal Arbitration Act applies, or the Georgia Arbitration Code applies.
You know, one other thing to consider is that the provision in the Federal Arbitration Act is pretty damn old, about the spending. I think it was written in 1925 or so. Yeah. And the 11th Circuit in the managed care case pointed that out and said, but, you know, Congress hadn't changed it, so we're still stuck with it. But I think as a result of that, most courts would probably say, we're not going to find that preempts another set of rules that provide more, a little broader basis for discovery and a little broader basis for non-party discovery. You know, unless this arbitration is being done pursuant to a contract that expressly said the Federal Arbitration Act controls. Because the fact that the Federal Arbitration Act has limited discovery doesn't, in my mind, mean that it preempts other rules that authorize more discovery.
I agree.
So I invite everybody to, if they have questions, to put them in the chat or put them in the Q&A, and we'll address them. Actually, I just got emailed a question, so I'm gonna forward this to the panel, and I guess it goes a little bit to Erica, what you presented about interim awards and filing the motion to vacate. It seems like a surprise, including me, to think that the triggering deadline on a motion to vacate interim award would start on the interim award as compared to when the issuance of the final award is. And I'm wondering if there's been any law challenging the question that you don't have to file the motion to vacate until there's a final award as compared to an interim award. Just interested on that timing for this question.
So there's no decision, but the statute is darn clear that if you want to vacate an award, you've got to do it within 3 months. When faced with that, take no chances, right? I would rather be filing my motion to vacate the interim award early than be behind, because there is a case law, Riddick, and I'm sorry, I can only remember the first name, Riddick, from the Georgia Court of Appeals, that said even a party who went to confirm, they got to the court, but they never actually petitioned to confirm the award within the year, and they couldn't get their award confirmed. So and Doug Yarn, has written his Georgia Arbitration Code book is fantastic. And in that, his quote is, the court takes those deadlines seriously. So I don't want to be the lawyer that finds out that filing after the 3 months is okay. Like, I don't want to, I'd rather be on the front side of that than asking for forgiveness. That's why uniform awards are just so problematic to me. I don't think that they're a good idea. I think partial final awards are a much better mode to get rid of certain issues in a case if that's how you want to proceed.
So I've got a question for both Erica and Joyce, which is, when a party brings up that they want to file a motion for summary disposition, how frequently do you allow it or disallow it? The JAMS rules basically say that you're only supposed to allow it if you think that they are likely to succeed on it, which of course is putting a cart ahead of the horse in a lot of ways on this. I have increasingly been reluctant to allow motions for summary disposition unless I think it's really something that is turning on like the clear language of a contract. That's going to be just a simple legal issue. But what do you guys think?
I generally will allow it. I mean, under the rule, they have to make some showing, some request to me to be able to do it. But, assuming that the reason is a good one, I will generally allow it. Because I've had a lot of arbitrations where some of the claims simply are not legally allowed. I've had people citing criminal statutes that they're not entitled to enforce. For example, theoretically, yes, could leave that for the final hearing and say, oh, and by the way, you're not a prosecutor, you can't assert that claim. But if I can clean it up beforehand, before the hearing, I think I'm doing the parties a service in getting rid of claims that there's no likelihood that they're going to prevail
on. My approach is more one of consent, right? Again, I'm going back to that theme that it's the parties' process. And most of the time when it comes down to contract interpretation, which is a really good one, question of law, is it, you have to make a determination of whether it's ambiguous or not. That is something that is a good interim, like in process type of decision. But I always issue them as, if that's the case, if it's an ambiguity, issue it as an order and not as a award. I don't call it an award. I call it an order. I think terminology can be very important because of the interaction with the statute. So I will allow it for that. I've done it many times where I'm looking for that interpretation. I will tell you, I have found that the law of diminishing returns. There is very little to be gained from in that kind of process. Including the interpretation of the contract, because you're not going to necessarily get all the issues out. And I've had it where we did it, we won, it was great. 4 days before the hearing, the arbitrator, they petitioned to bring the issue back in, and the arbitrator said sure. So, and I'll tell you who that was later. But it is, unless it's absolutely necessary, it really just adds additional expense to that. Save your arguments for the hearing. Arbitrators can whittle through those issues that can't be brought. You can in fact ask the parties in their pre-hearing briefing, articulate for me the reason why you believe that this contract says X, right? Because we all have that opportunity to ask the parties to direct your pre-hearing briefs to these issues. And so then you can put it all there. But if you are going to do it, again, just get back to the parties' consent. Let them have that buy into the process. And a lot of times they'll want that, because if it says yes or no, and they're going to be able to figure out whether to resolve the case, based on your initial interpretation of the contract, that helps them. But both parties will usually see the same issue and agree, at least with good counsel.
I'm going to jump back to Henry, who's using our Q&A well here. Henry, go ahead and ask your follow-up question since you're next in line.
I think they're actually two different ones, but on different subject matters. The follow-up to the discovery of non-party issue is whether y'all know of any ways around the lack of diversity problem of trying to enforce a subpoena against a non-party who's also non-diverse, because you can't get into federal court with no jurisdiction to enforce that subpoena.
Why can't you go into the state court?
Because they will say that the Federal Arbitration Act applies and it has to be in federal court.
No,
I thought that was the managed care decision.
No, the state courts can and regularly do decide cases under the Federal Arbitration Act. There is no exclusive jurisdiction over the Federal Arbitration Act in federal court. So Henry, take it down to Fulton County, take it to Cobb, you'll be good.
Talking about for enforcement of a subpoena, I could swear there are cases out there that say, no, you can't enforce it. You have to go to because the Federal Arbitration Act says you have to go to the jurisdiction of the witness or something like that. Then you have to prove federal court jurisdiction.
So let's just take, so you have a case where it's interstate, South Carolina and Georgia. And your client's in Georgia, your witness that you want to subpoena is also in Georgia. You get the arbitrator to issue the subpoena. I would serve it in Georgia. And then when that witness doesn't show up or doesn't give you the documents, I would invoke the Georgia Arbitration Code, take it to your local superior court, and they're going to have 100% jurisdiction under the code.
Yeah, adding to that, the Federal Arbitration Act does not preempt the application of other states' laws. For example, if you don't have an independent basis for jurisdiction in the federal court, federal question or diversity, when you go to confirm your award, you're going to have to go to state court, even if it's an FAA case.
That's actually what I did, and that's a very good segue to the next question, which is if one party moves to confirm their award, whether under the GAC or the FAA, is the motion to vacate a compulsory counterclaim?
I would say yes. That's how I've always treated it. Always. And again, you have such a short time frame to move to vacate, and they have such a long time to confirm that. So the disparity for those is you have 12 months to confirm and 3 months to vacate. So you're always going to be in a situation where your time may be running. Now I'm litigating currently. We've got a petition for cert pending as to whether somebody who doesn't counterclaim to confirm loses their ability to petition to confirm after the year because they didn't file a separate motion under 9-9-4. But it is practically speaking a compulsory counterclaim because the time is going to run if you don't. Now, that is not to say you couldn't split your jurisdictions. So they petition to confirm in federal court, you can move to vacate. In state court, I don't know why you would necessarily to do that, but you could, and then look at whether there's removal issues and otherwise, but you could file a separate case.
Anybody else want to add to that before we have a next question? Joe, Joyce, okay. Larry had a question. Go off of the speaker. Perfect, go ahead.
Yeah, backing up on the discovery question about the ability to subpoena somebody, whether it's under the state act or the federal act, would not the Uniform Interstate Discovery and Depositions Act apply? Where I have authority in my arbitration to issue a subpoena, somebody's in another state, And almost every state, not every state, is a member of that act that allows you to just issue the subpoena, send it over to the local court in whatever state they are. Is there a reason that would not work in parallel with either the Federal Arbitration Act or the Georgia Arbitration Code?
I'll be honest, I have not looked at that question, so I don't know exactly how it would play out. I would say that if you're in a matter that's controlled by the Federal Arbitration Act, I would think they may be reluctant to bring in the other thing you're referring to.
So the only thing I'd add, Larry, is that I think that act, and notably Texas does not have that act. So
they're one of, yeah, they're one of two.
Yeah. I think it really does speak to subpoenas issued by a court, which subpoenas in arbitration obviously are not.
Right.
We have had relatively good success in just serving the subpoena without getting much question from the subpoena recipient as to its enforceability, and able to negotiate a return, or just, sometimes they just flat out turn over the documents. And then you decide what your priorities are. If my recollection, and I haven't looked at this issue in a little while, so I apologize. My recollection is that because we now under federal law also have the nationwide service of process, if you have that kind of concept, you can tie into that with the Federal Arbitration Act. And then you have the nationwide service of process, so you can take your subpoena anywhere. Excuse me. But it is always challenging to get those folks there. And so a lot of times it does require back to Joe's point about taking the panel to the witness.
One thing that the Federal Arbitration Act does include, which is a little bit different and a bit of an advantage to the party seeking discovery, is that it says that if the party who has received a valid summons to bring books, records, or testify, in the hearing, refuses to do so, you go to the district court in which the arbitrators are sitting to enforce it, as opposed to going to the district court where the witness is to enforce it. And so that's probably gives leverage to the party seeking the discovery that, the witness is not going to be able to think, my hometown court's going to protect me here. You go to the United States District Court where the arbitrators sit in order to enforce it.
All right, we have another question. Ryan, I don't know if you want to unmute yourself and ask the question, or wanted me to ask it for you.
Sure, I'll try to articulate it a little better than I did in the Q&A. So I'm talking focus on the situation of compelling non-signatories to arbitrate, and I have a situation where you have a dispute between a builder, basically a construction contract, and you have a bond, and the construction contract has an arbitration clause in it. The bond does not, but the bond incorporates by reference the construction contract. So there's an argument that the bond company is required to arbitrate as well as the developer and owner. So I'm wondering what experience you have with that, and how that question gets resolved. In other words, you could resolve it on the front end and go to court, or the bond company could be named in the arbitration and risk getting an award against them, and then challenge it just like a personal jurisdiction challenge when the award is sought to be confirmed. So I'm curious as to your experience about that.
Joyce,
what you are describing is almost exactly, or pretty close to exactly, the Supreme Court's case in First Options versus Kaplan. The question there was whether or not the Kaplans individually were going to be liable. And in the arbitration, they objected to the jurisdiction of the arbitrator. The case was First Options against, I'll call them MKI, which was the abbreviation for it, and the Kaplans owned MKI. Both MKI and the Kaplans were drawn into the arbitration. The Kaplans objected to the personal jurisdiction of the panel. The panel said, no, we think we have jurisdiction. The case went on. First Options got an award against MKI and the Kaplans. Went to try to confirm the award. The award ended up getting vacated. No, the award got confirmed. It then got appealed, and the appellate court vacated as to the Kaplans. Then it went to the Supreme Court. So all of this could have been avoided. I mean, think of how many thousands and thousands of dollars went into this. But all of this could have been avoided by getting a court's opinion at the outset. Because alternatively, you're running the risk, so long as the bond company says you don't have jurisdiction and maintains that position throughout the arbitration, that any award against the bonding company won't hold up. Alternatively, the bonding company also runs the risk of having inadvertently somehow waived their objection, or being found up the road that they waived the objection. So it's complicated for both parties. But under the FAA, under I think it's section 7 and 8 or 6, it's in the paper, but you can file a motion or a petition in the federal court if you're in federal court. And there's a similar provision in the Georgia Arbitration Code. Petition to compel that they arbitrate. And then you can go through the arbitration and know that the award that you get at the end of the day, be it against contractor and bonding company, that it's not going to be subject to being vacated on the grounds that you didn't have jurisdiction, or the arbitrator didn't have jurisdiction over the bonding company.
The bond company has a lot of risk as well, right? If they don't participate in the arbitration and maintain their objection, then they're wrong on the jurisdictional issue. They never get to challenge the merits.
Potentially that's true. And that's why I said that they've got the risk of waiver, because they always have the opportunity to go into federal or state court and seek to enjoin the arbitration against them. And is their failure to do so a waiver? You know, I mean, creates a lot of issues.
It sounds like your position is that the court, or a court, is who decides that issue. In other words, the arbitrator is not supposed to decide that issue.
Because it is basically a contract formation issue. You know, did the bonding company agree to arbitrate? You know, and that in turn may turn on, you know, what's in your contract documents, you know, the incorporation by reference, etc. You know, so a lot of issues, a lot of facts. Safest course is to get a court to say, nah, you got to arbitrate.
Which they almost always do.
Joyce, have you looked at the question before, where you have two parties that are clearly subject to an arbitration agreement, a claimant and the respondent wants to have a third-party claim against you know, a party that maybe is not party to the arbitration agreement, and how you handle that?
It's really the same analysis. You know, is the third party did the third party hard to articulate it, because basically what you're saying is a claim over kind of situation, I think.
Right.
That the third party is liable for some or all of the damages that could be. You know, it's the same, because it's basically in that case, the respondent is becoming a claimant against the third party. Right. So it would be the same analysis, you know.
Yeah, I think that's right. And I think you can have the circumstance where, unfortunately, as an arbitrator, you have to say, sorry, you know, I don't have no jurisdiction over that third party. The fact that you've got a claim, if you end up losing this arbitration, you can then go to court and sue them on your cross claim, or your third party claim, but you can't bring them into this case unless I have some reason to believe I have jurisdiction over them.
I think you'd all agree that if it's in the contract, your ability to move to stay pending arbitration has been very successful if the contract language provides for arbitration.
Mm-hmm.
Mm-hmm.
Okay. I mean, that's sort of the result of I understand what you're saying, Joyce, about the third party issues that may not be by contract, but Erica, you said before, most courts are going to grant the motion to compel arbitration if it's in the contract.
Oh yeah.
Have you found arguments that try to squeak out of arbitration, even though it's in the contract? Any suggestions on defenses?
It's delay. Like what really will be is the significant invocation of the litigation process, so that there's been a waiver of the right to arbitrate, and that has been, you know, the subject of a number of Supreme Court cases and issues of late. There was a prejudice element that the Fifth Circuit had clamped on to that analysis, and the Supreme Court said no, that's not it. But there is the waiver. Have you waived your right to arbitrate? And I've been involved where I took over a case from somebody where there was a clear arbitration clause. The parties had, and my client that I took over the case for was the plaintiff and filed in court. We realized we were getting home cooked, and so we had to move to compel arbitration. And we're successful because no depositions have been taken. There had been motion practice, but nothing on the merits and stuff has been done. But in other cases, there's been a lot done. And on this question, and maybe Joe or Joyce can help me. There is the U.S. Supreme Court has a question in front of them this year on arbitrability. Do either of you remember it off the top of your head?
Sorry.
I do not.
Okay, I had it in my head and I lost it. So, but there is the Supreme Court takes regular interest in the interpretation of this nearly 100-year-old statute. And there is at least one or two arbitration cases on the docket every year. Oh, I know what the question, actually, sorry, Scott, it was off your question. So the motion to stay. So the question is, do the federal courts have the opportunity to stay the case for arbitration, or do they need to dismiss it? So what happens here is our courts will stay it, and then they will administratively close it. So they're not being charged, you know, the statistics aren't counting against the court. But there are other jurisdictions, and there's a split in the circuits that says they have to dismiss it when they compel arbitration. So that is up before the Supreme Court right now. So stay is not necessarily going to be guaranteed. I think stay has the better statutory language argument than dismissal does.
Great. Okay, guys, we're at the end of our time. Boy, that went fast. As we close, I really want to thank Erica, Joyce, and Joe for a great program today. Want to thank everyone for attending. Those of you who attended the annual meeting, thank you for taking the extra time to do that, and I appreciate you letting us start this program early. One last thing, again, an announcement for the April 18th program with our State Bar President, Ray Chadwick, on mediation issues. And again, you'll see the invite coming soon to you for the May 16th get-together for Meet the Mediators at the State Bar. Hope you join us for that. Thank everybody for attending. Again, thank you to the speakers, and I hope everyone has a good day. Thank you.
Thanks, Scott. Good to see everyone.
Ladies and gentlemen, this does conclude today's meeting. Thank you for joining and have a great afternoon.